Thanks everyone for joining me today on the next episode of the Morrison Report. Today we have with us Adam Morke. He is a tax partner with Stern Cohen. We're going to be talking about bare trusts. So, what the heck is a bare trust? Have you added your name to the legal title of a child's new home to help them obtain a mortgage? Or have you opened an in-trust bank or brokerage account for your adult children to help with estate planning? If so, you might have a problem. And these are just two examples of the many kinds of bare trusts that might exist. So under new tax reporting rules that apply to the years ending after December the 30th, 2023, you could be liable to a penalty of up to 5% of the fair market value of the home or in trust account if you don't report the arrangement, even if there isn't a penny of tax owing. So today we've got joining us today, Adam Morke, who's going to explain all of this. So let's start off with what the heck is a bare trust?
So first off, thanks for having me. So a bare trust isn't defined in the Income Tax Act, but in simplified terms, what a bare trust is where one person, and that person could be an individual or corporation, and we'll call them the trustee, holds title to an asset for someone else, who we will say is the beneficiary. But their sole purpose, the person that's holding title, is just to take instructions from the beneficiary and just do whatever they want. So this is different than maybe kind of a normal trust arrangement that people might think of. People think of setting up a trust for their children or grandchildren where the parents have control of the assets and they kind of decide what they want to do. Here we have an arrangement where the trustees are purely holding title and really don't do anything beyond whatever the beneficiaries tell them. And so the best way of explaining that further, I think, is by way of an example, the most common examples we see. Okay. So the most common example I would see would be probably a parent is getting a bit older and decides for, I'll call it estate planning reasons, that it would make their life simpler, or it will make everyone's life simpler on their passing if they were to add their adult children onto the title of either maybe their principal residence or a bank account or an investment account. And so they do that, but their intent is, this is still my asset. I own 100% of this asset. I'm just doing this for convenience for everyone, for estate planning purposes. Okay. That's a prime example of what we would call a bare trust relation. So the adult child that's being added onto title, we consider a trustee, but they're only on title and they essentially will do whatever the beneficiary, in this case being their adult parent, tells them to do. Okay. So from an income tax perspective, prior to this year, we basically ignored bare trusts. We weren't required to do any filing for bare trusts. And so this is why you'd never hear about it. This is why the general public has no idea what a bare trust is or that this is even a filing requirement. So that's the best examples or the most common examples I can give of what a bare trust is.
So let's talk about the scenario when it comes to real estate, when there are lots of parents who help their kids out in terms of buying a home, but they are on title. So why don't we sort of examine that scenario a little bit?
So I'll say with any scenario, it's always going to be, to use CRA's favorite term, a question of fact, which is to say, it depends on what the intent is. Okay. But in most cases, let's say the intent is likely that the, I'll say, adult child is intended to own 100% of the real estate, and they're just being added onto title for certain filing requirements. Okay. If that's the case, then there is a bare trust arrangement there. Okay. Where in that situation, the parent is actually the one that's on title and is trustee, and the child is the beneficiary. And so a tax filing is going to be required. All this tax filing is, though, just to be clear, it doesn't say what this bare trust relationship relates to. It just says who is the trustee, who is the beneficiary, and we also use the term settler, settlers who contributed the property. But settler in a bare trust context is typically the beneficiary as well. It's just naming those three parties and their address, their date of birth, their SIN, and that's it. Nothing else is told to CRA. They don't know what is actually held in this bare trust relationship.
Right. So, but it's the parent, if it was the parent on the name of the child home, it's the parent that has to actually declare this to the CRA. The child doesn't, correct?
Yeah, so it depends on in which manner we're talking about, but it is the trustee's relation requirement rather to do a trust filing. Okay, so the trustee in the context of a bare trust relationship is going to be the person that's on title, but isn't what we would call the beneficial owner. So the person that, call it, truly owns the property that would be entitled to the proceeds if they sold the property. So in the context of a parent being on title where their intent is that their adult child is, call it, really the owner, the parent is the trustee and the one that's required to do this filing. And as you started the introduction, it's a very significant penalty if this isn't filed. It's up to 5% of the value of the asset in the bare trust relationship. Now, I'll point out, because no one knows what a bare trust is, and it's difficult for the general public to figure this out. The CRA has said that they're not going to assess penalties this year if you file late. So the due date is March 30th, although technically because of Easter and the weekend, it's not due till April 2nd. But even if you file after that date, they're saying they won't assess penalties unless it's, I think the words they use, the most egregious situations, which I interpret to mean unless you're somehow trying to, I don't know, maybe commit fraud or you're doing it for some sort of criminal reason, then they're still going to assess the penalty. But for the reasons the average person would have a bare trust relation, they're not going to assess penalties for this year. If you late file, that doesn't mean if you never file, they still want you to file.
So is there an amount? So for example, is there a minimum amount? Obviously, real estate's pretty expensive, but if we're talking about an investment account, does it matter the dollar amount that you need to actually file?
Yeah, so there are some exceptions. Probably the most common exception that would apply to the general public. And so by that, I mean, without getting into some exemptions that relate to lawyers' trust accounts, the most common exemption looks at is the value of the assets in the trust at all times throughout the year below $50,000. But then even when you dig into that, it's only certain types of assets. So the assets would be like cash or marketable securities. Okay. So for someone that just has a bank account with their adult parent, it's possible or more common that they will fit under those exemptions because maybe there's only $20,000 of cash. When you get into investment accounts, been my experience that it's pretty easy, I'll say, especially in the GTA, to be over that $50,000 threshold.
And obviously, when it comes to real estate, you're definitely going to be over that $50,000 threshold.
Absolutely. Or if you can find something that's less than $50,000, please let me know. Yeah.
And so when they're filing, I guess they're filing, you said, by March the 30th or April the 2nd. What exactly what information are they giving to their accountant to do the filing? I'm assuming that this person is not filing this themselves. They're going to be working with an accountant to do it for them, correct?
Most likely. So the first thing I would just point out is the most critical thing for them to do is to tell their accountant. Do not assume your accountant is going to know this. Your accountant is not going to know that you are on title of real estate. There'd be no reason for them to know that. They likely aren't going to know that there's a joint bank account. They may not even know there's a joint investment account. Most accountants, they download the slips directly from CRA, so we don't see the names on the slips. It just automatically populates in your tax return. But that's the first thing I'm going to point out. Make sure you tell your accountant as soon as possible, as it's now March 18th. Tell them as soon as possible that you have this relationship.
Right.
Beyond that, you're really just telling them who the, call it, person is or persons they're on title, and who is what we call the beneficial owner. And for each of those parties, you're going to give them the name, address, SIN, date of birth, and confirm your tax residency. So for most people, they're going to be Canadian tax residents. Um, and that's about it, assuming it's a bare trust. There isn't really much more to report.
Okay. So now, why is the government asking this information all of a sudden? Why haven't they asked this before?
This is an excellent question that I would like to ask the government why they need this information. I think the intent is the government wants to know kind of who really owns an asset, probably especially with real estate. They want to know who really owns this real estate. Is it some numbered company? Is it really the numbered company, or is it the numbered company holding title in trust for the beneficial owner? So I think that was probably the intent
Mm.
without them explicitly saying it, and probably also to flesh out, are there non-residents that are owning real estate, but they're saying it's an Ontario numbered company to try to get around, you know, prohibitions on non-residents buying real estate.
Mm.
However, it's the way they've worded this. It's brought so many items that and so many scenarios that need to be filed here
Mhm.
for no reason, in my opinion. And even the information they're getting, it's so limited. I don't know how they're even going to use this information for anything that's useful. It would be different if they said, and I almost am fearful to put this out there in case they change the requirements, so we have to provide even more information. But I could see it being of more value if they said, well, what asset is subject to this bare trust relationship? But they're not even asking that. So all they're getting
Mm.
is the names of a few individuals or corporations as applicable, and no idea as to what this relationship relates to. Um, there's been a lot of articles in major newspapers complaining about these new tax filing requirements, explaining why they're quite ridiculous.
Mhm.
I'm hopeful that they'll either scale back the requirements or maybe provide more exceptions going forward. But right now, this is really what we're stuck with, which
Mm.
is for bare trust, you need to file by March 30th or again April 2nd, or otherwise face quite significant penalties.
Wow. And the penalties you said was like 5%. So, for example, if you have a house that's worth $1 million, they would owe 5% of that to the government if they don't file.
That's correct. That's
Ugh.
correct. So it's very significant penalty if you don't provide this information. And again, it, you know, it's maybe understandable in the context of they're trying to, I don't know, identify criminal activity. Doesn't seem very reasonable in just trying to identify, between parent and child, whether one or the other is on title of someone's real estate. It just the penalty is extreme relative to what they're trying to collect.
Yeah. I mean, it's funny because last year they started where you had to file that underused housing tax. This year it's the Bare Trust. I almost feel like, so what's it going to be next year? They're just, they seem to really be coming after information.
That, absolutely, yeah. And I mean, I think that's a large part of it. They're trying to gather more information, and I think probably there's good intentions as to why they need this information, but they are not designing those requirements in a reasonable fashion and casting too large of a net. And again, just the information they're collecting on these trust filings, it's not. I don't think it's that valuable to them.
Mhm.
So they're causing a lot of extra work for accountants. I can certainly tell you that much, and a lot of extra fees for the average person to just report a joint account or just report real estate that they have with a family member, or where a family member is on title just for estate planning reasons. It's
Right.
just producing a ridiculous result. So again, we're hopeful that in the future there'll be some scaling back of these requirements, but unfortunately,
Mhm.
right now this is the reality that we're stuck with.
And is this something, I mean, I think you mentioned this earlier. Is this something that all accountants even know about? Like, is it just new and fresh and people aren't really talking about it?
I mean, I think accountants will generally be familiar with the concept that there are bare trusts and that there's new requirements to file for bare trust. But again, I caution there's no way for an accountant to know that you have this bare trust relationship. I mean, it's a little bit different in some commercial settings where people use corporations to have the corporation's name on title because that corporation's filing a tax return. So
Right.
at least the accountant is aware of this existence. But when it's just individuals, things like, like I said, a family member, like an adult child on the name of real estate, like the principal residence, there's no income being reported on that. So there's no reason
Right.
for you to have ever told your accountant about that. And the same thing, the joint accounts with bank accounts, there's no reason for your accountant to have ever acquired or inquired, sorry, about those accounts. So, yes, I think accountants most will be familiar with the filing requirements, but don't expect them to know what assets you have that are subject to this bare trust arrangement because there's no way for them to figure it out.
Right. You mentioned something earlier about having, let's say, a property in the name of a corporation. You
Mhm.
have a property in the name of a corporation. Let's say you've got 3 or 4 people who are part of that corporation. They don't need to file because they're all beneficiaries of the corporation that are filing taxes, correct?
So again, I'll say it's a question of fact as to how that is structured. And so by that I mean typically, if you're buying real estate in the name of a corporation and the intention is that the corporation is the beneficial owner. And so by that, I mean, let's say you rented the property as an example and it
Right.
produced income. The corporation would report that income and it would pay tax on it. And then you would have shareholders of the corporation. If they wanted
Right.
money out of the corporation, it would pay dividends to them. So if that's the way it's structured, that's not a bare trust. You just have a corporation that owns real estate and is reporting income. But there are certainly other situations, especially in the context of commercial real estate, where what will happen is property is purchased in the name of, I'll just say, a numbered company. Okay.
Okay.
But the intent is that the beneficial owners of that numbered company might be one or several other parties. So on title, it just says there's one numbered company that owns this real estate, but in fact, the beneficial owners might be multiple parties. So
Mm,
continuing with that example, let's say that property was rented. The party that reports the income on that from that rental property is not this numbered company that holds title. It's all of the beneficial owners. And so this
mm,
is again more common in the case of commercial real estate, and this is typically done for legal liability reasons.
mhm,
I can't comment on whether that's effective. That's a question for a real estate and commercial lawyer, but
mm.
that's one of the reasons it is structured that way. So again, in those situations, there is a bare trust relationship and a bare trust filing that is required. But that will be easier for an accountant to discover because they are doing tax filings for that numbered company in my example, even though the tax filing is essentially reports nothing because there's no income in it, but there's still a requirement to file.
Hmm. So what if you own the property in the name of 2 names and you have a third partner that's actually not on title of the property, but is also a beneficiary of that property? And, each party is filing taxes on a regular basis as a part of their personal income taxes, not in a corporation. Is that a bare trust?
It certainly could be if, and
Okay.
based on that scenario, that likely is a bare trust. So if you had a situation where only 2 individuals were on title for some reason, but 3 parties were the beneficial owners, then yes, I would argue the 2 owners, each of them is holding an interest in trust
Yep.
for that third person, and so each of those individuals you would probably do it combined as one filing, but those other 2 individuals should be doing a bare trust filing to say
Wow.
that they are trustees and the beneficiary and settler is that third person. Again, just in relation to the
Wow.
one third
Okay.
interest. So yeah, you can see how there's lots of just kind of ordinary business dealings, I'll say, that are
Yeah.
entered into or have been entered into in the past that were accepted are acceptable, I should say.
Mhm.
But there was no tax filing requirement related to these sort of set of facts. And now there is. And again, the penalties are quite significant if you
Wow.
don't do the filing, even though again, there's no income tax here to be collected.
Yeah.
It's just providing information to the government. And for context, most other forms that you would provide information to the government, such as this is a bit different, but a common form that individuals will file is a form disclosing if they have foreign property over $100,000. The max
Right.
penalty there is $2,500, not 5% of the value of the asset. So the penalties are very significant, even relative to other tax filings that are out there that
Hmm.
require a lot more detailed information than this Bear Trust filing.
That is odd. That's very strange. Adam, this has been very enlightening for me. Lots of people to talk to say, hey, better make your filing. Is there anything else that you think people would want to know about the Bear Trust before we say goodbye?
I mean, I think probably the average person is just trying to get an understanding of, do I have a Bear Trust, especially when there's anything that's a joint account or, again, joint ownership of real estate. And we went through several scenarios where some common examples of joint trusts, but I don't want everyone to assume that just because of one of the examples we've given that it is a Bear Trust relationship. It's always a question of the facts and the intention. And so there may be scenarios out there where, especially for bank accounts as an example, where you've added a family member joint in the bank account, where maybe the intent isn't that, using my example, the parent still owns 100% of the account. Maybe they want their adult child to be entitled to half of the account. So, it really requires more of an analysis to get an understanding of everyone involved as to what is the intent. Once the intent is agreed upon, then an accountant can provide an opinion on whether you have a Bear Trust relationship. So if you have these, please present the information to your accountant, but please be prepared to give some background and some context as to why these joint accounts were set up, or why the ownership of real estate is held with multiple parties.
Interesting. So, if people have any questions, how would they find you? How do they reach out to you?
Yeah, sure. So you can visit our website, which is sterncohen.com. So sterncohen.com, or you can email me. My email is my last name, Morke, Morke, at sterncohen.com. Although I caution, if you're reaching out in the next week, we probably will have very limited availability to do filings by March 30th, and it will probably be the same for most other accountants. But assuming you have a Bear Trust, there isn't the late filing penalties this year. So it's probably something that's going to be filed after the deadline if you're just reaching out now.
Great. Wow. Thank you so much, Adam. It's always great to hear you and get some insight and information about what's really going on. And I think that this is some helpful information for people that they just might not be aware of, myself included. So thanks so much, everyone, for listening to the Morrison Report. Adam, thanks for joining us today.
Okay, thanks so much for having me. I appreciate it.